Hello everyone, this is Undivided. I'm Jason DeBias, super subbing for Wendy Jones and Ashley Clark. Wendy and Ashley won't be around for a couple of weeks, but they left me in charge. So when the cat's away, the mice will play. The inmates are running the asylum, so we're going to have a lot to talk about. We're going to have a couple of clips where we're going to talk about what's on my radar. We're going to have a clip that called Break It Down, where we're going to watch some political debates and analyze that. We are going to reflect on what happened the last couple of years and how we as a society handled it. I'm calling that not for me, but for thee. But first, things first. The Colorado Supreme Court ruled 4-3 that former President Donald Trump is ineligible to run for president under the primary ballot and under the general election ballot. It struck many that this ruling was even applicable to Donald Trump because he had not yet actually been convicted of what he's been charged and for in the court of law. But many legal scholars have went through the 14th Amendment and said that the accusations and evidence collected qualifies under the legal tenets of the 14th Amendment. In other words, close enough is the order of the day in the state of Colorado. That is hilarious. Joining us today is New York trial attorney and professor of law and ethics, Jeff Sheetzel. Welcome to the show, Jeff.
Thanks for having me, Jason.
Now, Jeff, you're a man of many hats, and I know you find more. I know you long enough to know that you find more solace in the court of law than outside. But I need your legal expertise in some of your wheelhouses, which is ethics, and I understand that you appeared in front of this judge.
Your question about I think you didn't.
Actually, I think I'll shape that question. The question, the most important question that everyone wants to know, to the layman, to even the people that are supposed to be educated on this, can you disqualify someone on allegation alone? And what was the evidence that led to their conclusion?
Right. Well, what you're asking really gets to the heart of it, right? The term isn't defined in the statute relied upon, which we'll get to later when we talk about Griffin's case, and in Section 5. But even if you assume strict adherence to the federal criminal statute in what they were analyzing in the Colorado Supreme Court, which, by the way, probably doesn't have the jurisdiction to go into an analysis on a federal insurrection charge, you still have to deal with the fact that he was never charged and he was never even prosecuted for any of this stuff, right? So there are huge due process concerns going on here. We have, in this country, across many bodies of law, we have a lot of overriding principles that sort of pave the way, right? So things like hearsay rules, things like collateral estoppel, things like the right to confront your accuser. And what they all boil down to basically is, if you're going to say something bad about me, I should be there to defend myself, right? So, the Colorado Supreme Court, in taking the January 6 hearings as their primary source of evidence, if you want to call it evidence,
or evidence collected, right?
Or, they're basically, what they're doing is they're sort of like, Jay, let's say you and I are running for class president, right? And the elections are in November, and you're going to have a party at your house this weekend, and you invite me over, and you say, hey, Jeff, come over to the party. I say, great, what kind of party? And you say, it's going to be an Everybody Hates Jeff party. And I say, well, what happens there? He says, well, and you say, well, we sit around and we try to down talk and humiliate you for 4 hours. And then I say, that doesn't sound like something I want to go to. And then lo and behold, 3 months later, the election comes up and you says, oh, well, you go in front of the student council and say, oh, well, we already decided at the Everybody Hates Jeff party that he can't even be student body president. So go, and then the court says, we agree.
Right. I think the part that's more scary about this, and I know I'm here to ask questions, but I'd like to say that there's a difference between all the evidence period and all the evidence collected, right? I mean, if they're basing it off of January 6th, how many of the files are not there because they're trying to protect maybe, there was this allegation of like federal agents on the ground. No one's actually answered a question on that. That's not admitted into evidence. These are the things where, like you said, not only, and it's weird because I'm trying to ask questions here, but it's weird in a sense to me that not only is he not there to answer, these charges. Like Jeff invited to the party, the only reason why you'd want to show up is like, okay, you don't like me for this, I'd like to say something about that, right? Because you can go option B on that, Jeff. So,
but there's also a different level of urgency, right? If you're invited to the January 6 hearings, and the most important part of it at the time is it's going to be something the Democrats get to put on TV to embarrass you, you may not show up. But if you knew at the time that a year and a half later, they're going to be using this to get you thrown off the ballot, maybe you would have shown up. You know, so it's a little unfair in that regard also, probably.
Right. I'd also like to get to the second part of my of the three questions, the three very important questions I had for my audience listening and watching. I'd like to explore Section 5 of the 14th Amendment that states that only Congress can enact this. Does this argument, which will obviously be present to, probably for SCOTUS to take a look at, does this argument have legs? Or
well, it's an interesting argument, right? And Section 5, originally stems from Congress having the authority to adopt legislation to enforce other parts of the 14th Amendment, which range from everything from birthright citizenship to procedural due process to equal protection, right? So its primary purpose back then was to ensure that states weren't enacting laws that were contrary to the 14th Amendment. So if they did, then Congress would use this section to basically overrule them, right? But it's a very interesting thing that the Colorado Supreme Court did, right? Judge Gorsuch, before he was a Supreme Court judge, was a federal district and then circuit judge, and he wrote an opinion back in 2012 that the Colorado Supreme Court cited in support of their position on this. It's a case called Hassan, where Judge Gorsuch had said a state court can make a finding that someone who wasn't born in the United States can't become president and can be eliminated from the ballot for that reason, right? So obviously it's distinguishable because, we have a perfectly articulated qualification in the Constitution that says you have to be a citizen of the United States, or born in the United States. Sorry. So they threw that in there, sort of. I call it getting cute, but knowing that this is going to be in front of Judge Gorsuch and he probably is going to be leaning toward going in the other direction. But the biggest problem they have with this argument is something called Griffin's case, which Griffin's case is a case that was decided by the then chief judge, back in 1869 or whenever this was decided, in the wake of the Civil War. You could be the chief judge of the Supreme Court without having sat on the Supreme Court. So the chief judge of the Supreme Court at the time was sitting in a district court, and he made a decision that generally, in reference to the Confederate officials that wanted to run for office, and it essentially said what they're arguing about Section 5 now, which is without a specific act from Congress, it's unenforceable.
Right. So.
And that's been precedent for 160 years.
But from an ethical standpoint, do we not see the distinction between providing proof of evidence that you were born in this country, as opposed to proving something didn't happen, just proving a negative, right? Isn't there a distinction between, for example, sexual assault, right? Like, how do you prove that you didn't do it? Or in Trump's case, with the evidence collected, how does he prove that it doesn't exist, right? So there has to be, at least with the birth thing, that you can't just prove a negative. Providing proof of something and providing proof that something never happened are two different things, Jeff. No?
But also, we have a statute that says these are the bright line requirements to be president of the United States.
Right.
And in this instance, we don't have a a statute that says under the 14th Amendment, this is what insurrection is, and these are the elements. And more importantly, what do you do if you make a finding that there was insurrection? Who has the authority to enforce it? What
Right.
is the process? And that's what this, Section 5 authority of Congress would have given guidance on.
There's
And that's why there's been a 160-year president that hasn't, it's been completely unassailed. You have some cases that have been attacked and attacked and attacked, like Roe over the years. This case is unassailed, 160 years until now.
Yeah, and I think that if you remember its original intent, right, it was to make sure that Confederate states like Mississippi and whatever don't commit an insurrection and take over the states, which goes back to what I was saying, what you mentioned off camera for me, Jeff. I actually cited in my introduction that they were keeping them off the primary ballot and off the general election ballot, and you believe them. I might be incorrect on that. If this is only applicable to the primary ballot.
Right. My understanding is that the Colorado Supreme Court ruling only applies to the primary ballot, which is why you've got the state Republican Party leading the charge on the appeal. If this were to go, because the bottom line is, in terms of the primary, who cares?
Right.
The only real danger of this case is the potential harm it's going to do to the country over the next 100 years.
Yeah.
Trump's not winning Colorado anyway. Trump doesn't need Colorado's electoral votes to win the
No.
Republican primary. So the question then becomes, what happens when he wins the primary anyway, and now it's time to get on the federal election ballot, which is it's gonna be a new can of worms.
Absolutely.
It may come down the same way, but there's gonna have to be another process.
Well, if for the Republican primary, enlighten me, is Colorado a winner take all?
Yeah.
For the primary, okay, and of course for the general election, each states are winner take all for the electoral college for each states. Got it, right? There are no splits on those.
Well, there's no split on the primary, I believe. I mean, Maine splits for the presidential, but I don't think they split. That's a little outside of my scope.
Right. Well, there's not enough electoral votes in Maine to actually make a difference. I mean,
well, did you see today or last night?
Tell me.
The Secretary of State in Maine has now thrown Trump off the ballot in Maine.
Oh, good.
But she basically, it's going to be much ado about nothing, because she basically deferred to the Supreme Court, whatever they're going to say in the.
Right.
In the Colorado.
And we're definitely going to cover that at the end of this segment. The reason why I brought this up, we've known each other for a little bit, and we have political ideology differences. So I'll just cite by saying that I've never been and never will be the biggest fan of Donald Trump, but this is very, very scary for me and a lot of people, for a great section of America who are not voting for Trump, but are scared because if this sets a precedent for him, it's only a matter of time before it sets a precedent to get to someone they do like, right? So, Jeff, before you answer this, let's not have. I'm not going to shape this into a dichotomy. I'm going to go in the sections, okay? There's a section of Trump people that shoot a person on Fifth Avenue, and they'll like me anyway. That's its own people. There's a group of Biden won 81 million votes, but I wouldn't be surprised if more than half of those votes weren't necessarily voting for Biden, but were voting to make sure Trump didn't win. Then, of course, you have the blue no matter who crowd. So you have 3 or 4 sections. But now you have someone like Robert F. Kennedy right now who's polling at 24%. Which is an unprecedented high for someone that's running under the no party preference, not independent, but NPP, and he's not on the ballot in Colorado, and there was no legal or moral justification for that.
Which is wild. That's wild.
Yeah.
I haven't looked into the legality of what the rationale was. I don't know if did they say it was some type of failure on the behalf of his campaign to get to get the correct signature? Like, what did they say?
Well, this is
I would
something
do.
I'd like to look into and definitely have you back on
No,
future episodes and we can talk
no,
about that
definitely.
because it is unprecedented to have someone who's not actually part of a party to poll at 24%. You know, if you remember Ross Perot, I think it was 9% to get in the debates, and because too many people met that threshold, they raised the threshold to 15%. And you and I can do an entire section on how difficult it is for someone that's not left or right to win the presidency, right? Like, I mean, even if he wins the most votes, there's a threshold for the electoral college, right? So,
Yeah.
right, and if you don't meet that 280, then Congress votes in the president, and I think the Senate votes in the VP. So that would be a hot mess for a third
Yeah.
party to even shake up things. But last but not least, and thank you, you're taking. Um, your time is exceptionally valuable. My time's valuable, but you got
No.
places to be. So, um, I mean, you might actually, right? You got a kid. You might want to go and chill with your kid right now. So that's quality time too. So here's my last question. Based on your legal expertise, what is your prediction for SCOTUS for the Supreme Court of the United States? And is this something that most sensible lawyers agree with behind the political spectrum?
There's broad-based agreement amongst anyone who isn't part of the political class, and basically hoping instead of using their head that this is going to be overturned by the Supreme Court. It's absolutely 100% going to be overturned. The only question really is what rationale will they use? What will be the impact of that rationale? Because of course you could have some rulings that will put a nix on this for every single state in the country and kill every single lawsuit in the country like that. And you'll have, other ways that they could come down on this that'll only apply to this case, right? So it's that, and then the last question is, will it be unanimous? It really should be unanimous, but you never know with the voting history of the liberal block of the court. We'll see. But there's several things that could happen, right? So the first thing is that the Supreme Court could just say, look, um, you're a state court. You don't have the authority to consider whether the federal Constitution bans Trump from the ballot. And that goes a little bit into what we were saying earlier and the rationale behind citing the Gorsuch decision in Hassan, right? Um, then there's, the next argument is what you already hit on with the Section 5 with the Griffin's case. And, that has a little bit more teeth to it only because it's 160 years of precedent. And, you'll get people on the other side of this issue that are going to be quick to jump up and say, and watch, this is going to happen. Oh, well, the Supreme Court didn't care when they were overturning Roe v. Wade about precedent.
Mhm.
And that's one of the arguments that you're going to hear, right? But it's still it's a solid argument. Um, they could come out, and this is one we haven't talked about yet. They could come out and say the wording of the 14th Amendment, Section 3, doesn't apply to the President of the United States. He's not an officer under the meaning of that statute, and that's another reason why having Congress acting upon that
Yeah.
and issuing legislation would have helped. It would have given some guidance,
Yeah,
right?
because the presidential
Um,
oath says support, doesn't say support and defend, right?
yeah,
So there's a
but the
wording thing there. There's a technical objection that goes with that.
yeah, but the big one here, um, and this is really, it could be a nuclear bomb and it could be a mosquito bite, depending on how the Supreme Court wants to play it, because there's a tendency, it's a gentleman's game up there, and there's a tendency not to want to embarrass the lower court. So it's going to be very interesting to see how they come down. And the other issue is Roberts is really, he's really shown a propensity to, or maybe he's very cognizant of the political implications of rulings that come down and whether they're completely partisan rulings or whether they're unanimous rulings, and he makes an effort behind the scenes to turn non-unanimous rulings into unanimous rulings when he can, especially when he sees something as that could be politically divisive, right? So
do they let him vote last? Does he see where the other 8 people are going first?
well, that's part of it, right? But he's the politician of the court. Like he's the
Right,
one looking out and saying, "Oh my God, this is going to have this effect on America if we do it this way. Let's do it this way, and vice versa."
right,
Which you could argue that that's not the role of a Supreme Court judge, but that's who he is,
right,
right? So the big one is really um, the Supreme Court saying your legal conclusion is flat wrong.
right. Or the
Trump
procedure,
did,
or the
Trump
procedural.
didn't.
How about the procedural rule, right?
Well,
If
that,
Section 5
that
clearly says only Congress can enact this,
right, but
isn't that a procedural violation?
we
Yeah,
covered that one before. But
right.
this one would just be no, he didn't commit insurrection,
Oh,
and so they could make that finding. They could look at the same evidence because the problem when you deal with an appeal, right, is you only have the record from the court below. So the Supreme Court can't take the record of the case, look at it, and say, well, we need to see more information. All they have is the January 6th hearing stuff here.
right,
They can't do that, right? So it's unlikely that they will say, that you'll get a majority of the justices who are willing to say Trump did not commit insurrection based on this record.
right,
And then even if they were to want to do that, then you've got the Roberts motivations coming in with, we don't want the 3 Trump appointees coming out and saying Trump didn't commit an insurrection.
right.
And
There's that.
because we've already got enough problems going on with division in this country. But what I think is the most likely outcome, which would be unfortunate because it won't do away with every other case in the country, is they're going to come out and they're going to say the lower court lacked sufficient evidence to come to the determination that they came to.
Right,
And then so that's gonna and they're gonna send it back down, and it's gonna kill that case, but the cases all over the country
right,
are still gonna be alive. Whereas if they were to say the wording of the 14th Amendment doesn't include the president, boom, all those cases are over tomorrow.
right.
It kills the issue, right? So the big question is how they're gonna kill this ruling. It's not whether they're gonna do it. And you've seen it's however many states it's been. I think it's in the tens of states now that have some type of litigation going over this. We've already seen notable swing states: Arizona, Michigan, Minnesota. Which Minnesota's in play now. If you look at the most recent poll,
Yeah, Michigan as well.
they've all rejected the Colorado court's opinion.
Yeah,
So they're an extreme outlier. It's 7 Democrat appointees, and they only got 4 of the 7
right,
on that court. So I mean that tells you something. And again, this is something that we've talked about, off camera. But this is a state court making these determinations. These aren't Supreme Court justices who were the deans of Harvard and the most qualified people in their field coming in and Senate confirmation hearings here and there. These are guys that started their career putting up lawn signs in your front yard saying vote for me,
right.
which doesn't mean they're bad guys, but it's when you're deciding something that's going to turn the course of the country potentially for the next however many years, you might want the best and brightest on it.
I think I find it interesting that even that the more states that rule against this might make the Supreme Court not be concerned less about embarrassing the Colorado ruling, which many consider an embarrassment on its own, right? And thank you for working through this, because when you have people on both sides, lawyers actually, and smart people saying that there's something there, and you have lawyers saying there's nothing there, I want to thank you for taking this time to be more specific and acute detail from the subjective reality of what we both believe is to come. We believe the Supreme Court is going to strike this down. The question is it going to be 6-3? Which is going to create more partisan divide, or is it going to be 9-0 where everyone's just going to be like, hey, okay, you know what? This is nonsense. We'll see, right? Jeff, thank you so much for coming And ladies and gentlemen, this is Undivided. We are going to take a break, and we'll be back with more.
Thanks, Jay.